Okay, we're here to celebrate the UN principles and guidelines, and we should begin with them, and I duly put them up. I'm sure you're all familiar with them. They are exemplary. Those who have drafted them should be commended. That's from a principle, that's a guideline, and in a sense their work is now done. And I have one simple issue to take, which is this bottom-up meeting top-down? Okay, these are the top-down principles. How do we make them real? And you make them real, I think, in two ways. One of which Patrick has led on in a way, which is the legal aid administrations, the legal aid boards, ministries of justice in each country must take them up and make them real. But I'm going to talk today about the value of involving practitioners in the definition of standards. And I'm using some words precisely. Practice standards. I'm using the word practice precisely, if not, as we might say in English, a weasel word. Because what I'm not saying is professional standards. There is an issue here about who sets the standards for work relating to clients. Because you would think, in principle, it might be the profession. And certainly the profession and most bar associations would very much see it as their responsibility, and quite rightly so. But the difficulty is, in a number of jurisdictions, including historically my own, the bar, the law societies, have been reluctant to tell their members what they've got to do, to involve them in more than the minimum work. And so you have a tension, which was referred to, I think, by Zaza yesterday, where the bar association can be at best neutral and at worst hostile to the development of practice standards, and you've got to find some way around it, or, better, the practitioners who are actually involved in the work have got to find a way around it. And I think the methodology to use is to get the best practitioners together to develop practice standards. What would they say is the best thing to do in a case? And you could do that in a variety of ways. The best way is actually what ultimately happened in England and Wales. The Law Society of England and Wales, when quality became an issue, ultimately provided a whole book of standards, what it expected Defence Counsel to do, Defence Solicitors to do, and that has gone on through other quality measures. A technique that Zaza has used, the Open Society Justice Initiative, to which I pay tribute, is you set up, at the beginning, a pilot public defender scheme, you put people in, you give a small number of lawyers the sense of an elite. This is my description rather than Zaza's, but it's my observation. And you get them to lead through in that jurisdiction a rising of standards. I don't think they should be drafted by the Legal Aid Administration, but they should be supported by the Legal Aid Administration. And as a practitioner, let me say, there is a little tension between the Legal Aid Authority and the practitioner, and that's about money. And it may well be that the Legal Aid Authority will be more careful with what it's authorising in terms of the time that will be taken. That will be, quite likely to control the budget. Practitioners may have to say, as has happened in the States, well, you can't expect us to do more work than this if we're going to do it properly. You want the support of the relevant ministries, which is important if you are in a battle with the bar. And practice standards are not neutral and bureaucratic. They are part of a dynamic process of a profession working itself out. Just from my experience of working in Moldova, there was a much wider problem than legal aid. There was a very sharp division between the education that people had in university and practice. There was none of the clinical legal education which takes place in the States, or the vocational practice that takes place in the UK or Australia. You were basically straight in. And so the development of practice standards was a valuable part for the profession as a whole, one hopes, of people who are going to be practitioners recognising what it means. You can take various examples around the world of practitioners writing standards. I've referred to the UK. I was also going to take the example of Moldova, Georgia, and Ukraine, because these are three jurisdictions that have done it themselves individually, and then have collectively met and sought to come up with a common set of standards. Zaza has put these on the stick that you will get in the end. So though you haven't seen it now, you will see what was produced. And what was produced is it's not what is in the standards that is important, really. You can make your own choice of what would be important in your jurisdiction. It's the process of how they were gone about. But these are jurisdictions which are broadly the same and from which there's some value of them working together. This is a direct cut and paste from the preamble to the document, and I put it up just to make some practical points about other attempts to do the same thing. Number one is brilliant. It is a lawyer's guide developed by a couple of lawyers in the Public Defender's Office in Chisinau, Moldova, and published by a profession that has not been too welcoming to standards in its professional journal, and thus recognised. There is only one disadvantage to it. There is only one person in this room, and it's not me, who can read it, because it's in Romanian. There may be others, but I only know of one. So it's not been translated, but it's a good example, and it's not it's to be quoted. The next two are in for the mission. I'd be interested in participation from Ukraine and Georgia, because they use the word professional standards. And I know in Georgia at one time that got them in trouble with the bar, and there was a row about whether they should be setting professional standards, and I've referred to that. UN principles and guidelines, who could not refer to them now as a source? And then we have two, which are illustrative rather than definitive. The Public Defender Service document from the UK has one great value. It's short, 14 pages, 14 points, 2 pages, very clear about what it's setting out. It's in contrast to, there will be various other documents I could have taken, I'm sure, from the United States, the NLADA document, which is interminable. It's about 30 pages long. It is exhaustive and exhausting. It's absolutely geared to its own jurisdiction. It takes you in detail with how to deal with, quite rightly, through US-specific procedures, but when you take it to another jurisdiction, it's a kind of turn-off because it's too long, and it illustrates a point. I don't know how that document works in the States, but there's a point about length for these practitioner standards. These are practical standards, practice standards, and there's a real value in them being short. Because after all, you can talk about quality in the abstract, and what does it actually mean? When we come down to it, what are the key indicators of quality from a practitioner's point of view in a criminal case? Well, they are. Were you there for the interrogation and the interview with the police or the prosecution? Did you prepare the case and take instructions from the client before you went into court? How did you behave in court? And that's basically it. So they're very, very simple. You can build up from that. But my basic point is quality. You can get very abstract about it, but in criminal cases, particularly in jurisdictions where you're developing legal aid, it is a very, very simple concept. Here is just the main headings from the first paragraph of the 3-jurisdiction document, just to show you how it goes into detail. There are about 13 or 14 paragraphs of this kind of thing. And then we come to just the final conclusions. 1, as Marshall McLuhan said, the medium is the message. The process of actually working these standards out is probably as important as anything. Getting lawyers talking about, well, what would you do in that case? What would I do? What's the best thing? That's a really creative process, and it may well be that the value of practice standards ends once they're finished, but a lot of value is in the process of determining them. They're really good for building teams. They are really good too, I think, if the profession owns them, for building a profession, particularly in jurisdictions where a profession really needs to build itself. They will raise issues for the justice system as a whole. You won't go through practice standards without raising the kind of issues that Ade's been talking about. They provide a really good basis for a whole number of things. I've just put training, but they are the basis of accreditation, checklists, peer review, quality assurance. They are the bedrock, and it's really important, and dealing with complaints. It's really important that they are based on practical practitioners. So they are bringing together of international and national standards, and whether you say it's bottom-up meets top-down, as my chair prefers, or the other way around, as I put it at the beginning, it doesn't matter. The two are locked, just as the upper jaw of, the other upper teeth of a jaw, it doesn't work without the bottom teeth. If you want to grip on quality, you need the both.